Welcome to Soundbites for Quarter 1 2024. In this podcast, we look at the recent Court of Appeal decision in Miller and Irwin Mitchell and some of the risk issues around retainer formation and duties of care. By way of background, the claimant, Mrs. Miller, broke her leg whilst on holiday in Turkey on 13th May 2014. She was treated both in Turkey and on her return to the UK. Unfortunately, her condition worsened and the leg had to be amputated in November 2015. In terms of her claim, on 15th May 2014, Mrs. Miller notified the travel agent, Low Cost Holidays, of the accident through its representative. She contacted Irwin Mitchell on 19th May after seeing an advert for their personal injury service. On 20th May, Irwin Mitchell asked for documentation to assess if it would take the matter on. This wasn't received until April 2015. Following the amputation, the case was referred to Irwin Mitchell's multi-track team and a CFA was sent to Mrs. Miller in January 2016. A letter of claim was sent to Low Cost Holidays in February and passed on to its insurers, who rejected it in July for late notification. By that stage, Low Cost Holidays had gone into administration. As a result, Mrs. Miller brought a loss of opportunity claim against Irwin Mitchell. This involved an analysis as to when any contractual or tortious duty had come into existence. On current case law, an implied contractual retainer can arise if it can be inferred from an objective assessment of all the surrounding circumstances. Similarly, tortious duties can be implied if there's evidence of an assumption of responsibility towards an individual or in a matter. It was accepted in Miller that there was an applied retainer from the dispatch of the CFA in January 2016. However, before that, on the facts, there was no implied retainer or any assumption of responsibility by the defendant. Instead, the firm was fact-finding to establish if there were a viable claim which they would take on. The court found in any event that by April 2015, when Mrs. Miller provided the documentation originally requested in May 2014, there was no chance the insurer would have accepted no notification due to the passage of time and likely prejudice to the insurer. Some takeaways for practitioners and their professional indemnity insurers. Retainers can be implied retrospectively from a subsequent objective analysis of circumstances and conduct, giving rise to contractual and tortious obligations. Given that, if you need the client to provide more information before you decide to take them on, make that clear, and also make clear that there's no retainer pending receipt. At that point, you'll consider the information and decide whether or not to act. If you decide not to accept instructions, state that expressly, perhaps in the form of a non-retainer letter or email. If you do decide to act, document the retainer. As an insurer, we still see cases where this is not done. The result? Firms could be subject to implied obligations which they not accept in a formal retainer or in their standard retainer documentation. Ultimately, the aim is to reduce uncertainty in your dealings with potential or actual clients, and with it your risk.